Hello and welcome to Big Deal. I'm Nisha Poddar. Now, market regulator SEBI has recently amended the norms governing promoter disclosures of listed companies. Listing obligation and disclosure requirements, or LODR, has been amended on the aspects affecting the management and control of listed companies to include all binding and non-binding agreements by the promoter's family, and it also entails material rights of the investors and any agreement between them. These are supposed to be disclosed by 31st of July to the listed companies. Now, as the deadline nears, how prepared are the companies as well as the shareholders and promoters to comply with this, and what is the impact of this development? Let's find out from two experts joining me today on Big Deal, Cyril Shroff and Dinesh Kanabar. Gentlemen, welcome to CNBC TV18. Cyril Shroff, beginning with you, what is the broad intent of this amendment?
So just to pick up from where you left, Nisha, I think what has happened is that the SEBI LODR regulations have been amended, and the amendments are now already in effect from 14th of July. And whilst they cover a number of topics, the points relevant for today is two particular clauses, which is Regulation 30A and 31B. Regulation 30A deals with disclosures of agreements at the shareholders level, whether it is promoters, it could be even other investors as well, related parties and others. So basically the ownership class that sits above a listed company. And 31B relates to sort of special rights. So the intent, I think, as expressed by SEBI itself, is twofold. One is to bring greater transparency so that the public shareholders who may or may not be aware of these arrangements are specifically made aware, because this would then be in the public domain. And implicit in that is to reduce the so-called information asymmetry. And they may be in recent cases not exactly relevant to families, but which may have prompted this. I think the Amazon future dispute was probably one of the reasons which may have prompted this. SEBI had put out two consultation papers in November 2022 and February 2023, indicating the intent of why they want to bring about these changes. So it is broadly in the direction of improving governance in public markets by enhancing the level of disclosures. And the interesting thing is that these disclosures apply even if the company is not a party to these arrangements. Could be purely private arrangements, family constitutions, family agreements, family understandings. All of that has now been brought into the net.
That's right, and more disclosures, more transparency, and also to contain information asymmetry. That has been, the path that the regulator SEBI has been taking through various measures. Dinesh Kanabar, how is the industry really taking it at the moment? What's the feedback coming in from the companies as well as the promoters and the investors for complying to this? And the deadline given is also very short.
So two parts to that question, Nisha. First of all, we need to recognize that while in some sense this requirement is new, there was already an existing requirement which basically said that all shareholders agreements, family agreements, etc., which were binding and which were not in the ordinary course of business were required to be disclosed. So as it is, listed companies had that obligation, but the two primary conditions was that they had to be binding, and second, they had to be not in the ordinary course of business. Then they were required to be disclosed. Now we need to go back and look several years back to go back and say that here are arrangements. And now again, the requirement, as Cyril rightly explained, is far broader. So any requirement which could impact management, which could impact control, which could impact restrictions or pose restrictions on the company, or which could sort of put any liability on the company, which is far broader than what currently existed, are now required to be disclosed. And therefore, companies need to go back and look at the arrangements they have entered into. So let's say, for example, as Cyril rightly mentioned, we are talking about shareholder level things. But if, for example, there are two brothers, as an example, and they have parted ways, and there are territorial rights carved out, or there are business rights which are carved out, which earlier may have been taken to be in the ordinary course of business. Now you need to revisit. And again, look at two words which have been put out. Earlier it was binding. Now whether it is binding or non-binding, earlier it was, if it was not in the ordinary course of business, I had to make a disclosure. Now there is no such requirement. So companies need to re-evaluate several of the things that have been entered into past. They could have been entered several years back. As I said, territorial rights, business rights. Again, now KMPs have been covered. So for example, if apart from ESOP, there are other things which have been committed to KMPs. So in essence, Nisha, what we are seeing is companies go back and look at several of these arrangements between themselves, between directors, KMPs, etc. And the key words again, binding, non-binding, whether or not in the ordinary course of business, and again, whether it impacts management, control, imposes restrictions, company can or cannot do something, or any liability. You know, the word liability is a very, very broad word. So all the agreements which are pending need to be evaluated in the light of this, and therefore one needs to start now making a call of what is required to be disclosed, and one is doing that. One needs to be conscious that if these agreements were entered way back in the past, was a valid decision made or a judgment call made at that point of time that this was not disclosed because it was not in the ordinary course of business, etc. So we see several of the companies, promoters, shareholders go back and look at variety of this and come back to say, here are the agreements which earlier were not disclosed, now they need to be disclosed. And obviously then there is an issue on what is the impact of that on the company, its performance, on its market price and all of that.
Right. So very important comments there, Dinesh Kanabar. Taking off from there, Cyril, Shroff, two important aspects that I picked up. The key words, and of course, is open to interpretation, and is it well understood and defined in your view legally? One is non-binding agreements also come into the fold of these disclosures now. And second, something which is not in the ordinary course of business also needs to be disclosed. Is the definition now clear? And by way of this, in the private space, whatever agreement has been really done by the family members or the promoters or the investors or the private equity investors, all of that comes into the fold of disclosures now?
Yes, I think there is a lot of ambiguity on several of the expressions. I mean, one is on purpose and effect, binding, non-binding. All of these expressions will need to be defined. What is material impact on management and control? These are areas which are up for determination. And I think there is another angle which I think Dinesh Bhai partly adverted to, is that even if these are private arrangements, sometimes nobody except the family members know about it. They're probably sitting in, the chairman's home, and nobody in the company knows about it. How is the company ever going to find out about this? And the thrust of these regulations casts the burden on the corporate entity. So there is a lot of ambiguity also in terms of what is the impact of this and who is going to suffer the consequences. Is it the company that is going to suffer the consequences, or is it the shareholders? They are not saying so, but does it mean that these arrangements are unenforceable? And if so, why would that not be an overreach to say that private arrangements which are otherwise perfectly enforceable amongst the parties will not be enforceable just because you didn't disclose them? So there is all these gray areas on the frontiers of where kind of the laws relating to public markets meets the private domain, because a lot of these things are part of the promoter's private wealth. It is relating to the arrangements relating to their private domain. What is succession, for example? The succession may be a very secret topic that is dealt with in a family constitution or some other arrangement. Does it need to be disclosed? The breadth of the regulation seems to suggest that everything, if there is an arrangement on it, needs to be disclosed. So I think part of what corporate India, and particularly the owner class, needs to consider is whether this is an overreach by public markets into the private domain.
That's right. In fact, you raised a lot of points and ambiguity and grey area, and I'm sure this will really evolve. But a clarity coming in from the regulator or the experts and a consensus being built on that is going to be very important as part and parcel of the evolution of this new compliance burden. Dinesh Kanabar, you mentioned that some of the agreements which could have been reached by the family constitution, family agreements, even non-binding in nature, way back, and whether it holds true right now or not. But whatever was there and is existing as of today needs to be disclosed to the companies by the end of this month, and the company needs to disclose it to the exchanges in a few days from there. So how do you see this? Are the promoters going back to the drawing board and concretizing some of these agreements which were made way back?
It's actually a very, very interesting question, Nisha, and I go back to what Cyril mentioned earlier. So if there are private arrangements which the company is not aware of, now the promoters are required to disclose it to the company by 31st July, and company in turn is required to disclose it to the regulators by 31st of August. So apart from the fact that the window is very low, but a number of questions which again, I'm sure councils will sort of look at from time to time as to how does SEBI reach out or extend its ambit to promoters, private arrangements, etc. Does it have a right to do so? Does it not have a right to do so? And again, what happens if these are not disclosed to the company, because company may not be aware or a party to any of these? Otherwise, they would have been built into the articles of association. I'm presuming that none of this has happened thus far. Otherwise, they would already be in the public domain. So if these are not disclosed to the company, and therefore the company is unable to disclose it to the regulators, what happens to those agreements? Coming to a specific question, yes, every promoter group will now need to go back. And the reason why this becomes very, very cumbersome, onerous, and a lot of gray area around is that some of this might be pure internal to the family. So let's assume that there is a family comprising of a number of members and there are a number of businesses. There are so many groups, particularly in the South, which have well-defined family constitution going back generations, and there are several people in the business. And all that the family constitution provides is the process of consultation between family members. Now you need to go back and interpret as to whether this has an impact on management, control, liabilities or restrictions on the company. And that may not be a very easy take. So for example, if family members have taken charge of specific areas of business, all they need to do is that if there is a material capital expenditure, they need to go to the family board and have a discussion. Now, is that a restriction, not a restriction? Does it impact control? Does it impact management? These are not easy questions to go by. And again, Cyril made a point in a different context to say that this is sort of a private domain and public domain encroaching on each other. And therefore, to make that call is not an easy call, but it is obligatory upon all companies, listed companies, to go back to the drawing board. And remember, here again, the reach of this particular amendment extends not only to a listed company, but things happening with holding companies, subsidiary companies. So we are looking at a fairly broad thing. So
yes.
If, for example, there is a listed company, there is a subsidiary beneath, and the subsidiary has got agreements which are of that nature, they need to go back. We are looking at also directors, we are looking at KMPs, and then therefore the breadth is enormous.
Yes.
And the area of grey only goes on increasing.
All right. So what I've understood is that there are some ambiguities, and who bears the burden of non-disclosure of this norm also, whether the company or the shareholder, the promoter, investor. That's also one big question that needs to be addressed. But I would say, in my understanding, what SEBI and market regulator is trying to really address is the timing of the dissemination of a classified information regarding the impact on a listed company by the promoters or the shareholders. So they time the public disclosure, while SEBI wants an an immediate disclosure so that the investors can really take note and cognizance of that, especially in the cases of either a sale, acquisition, as well as succession and many other material developments. That's my understanding. But we'll slip into a short breather on Big Deal and we'll continue the discussion on what's going to be the impact of these disclosures and more compliance. That's after a very short break. Stay tuned to Big Deal.